Hello again, my name's Jason Perkins. I'm a Georgia workers' compensation attorney, and I'd like to welcome you to another edition of my Georgia workers' compensation video series. In this series, I provide you helpful information about Georgia workers' compensation law. Today, I want to talk to you about some recent changes that have been made in that law. But before we jump into that, be sure and be on the lookout for my next video in this series where I'm going to discuss the Form WC-14, which is the form from the State Board of Workers' Compensation that you or the insurance company can use to request a hearing in your case. Now, let's talk about those recent changes in the law that I mentioned earlier. There are three recent changes that have fairly significant impacts on Georgia's law. The first and the most recent change is the introduction of what's called a Form WC-PMT. This is a document that's being used to address the problem with medical treatment authorization. Medical treatment authorization, which is basically getting your medical treatment you need because you're injury approved, has been one of the biggest issues in Georgia workers' compensation law in recent years. Basically, you've run into significant delays getting surgery or testing or any treatment that you need because you're injury approved if the insurance company won't contact the doctor's office and give approval. The Form WC-PMT is the solution that's being proposed to that problem. Basically, it's a document that you or your attorney can use to request a conference call in front of a judge in certain circumstances where the insurance company is not approving medical treatment. And the insurance company can then either approve that treatment, deny that treatment, or the conference call can take place and the judge could either order the treatment to take place or deny it. So hopefully that change in the law in that form will be effective in making sure that medical treatment gets approved on time so that you can recover from your injury better. Second change that's been made is a change in the rule about nurse case managers in workers' compensation cases. Nurse case managers are people who are hired to basically do rehabilitation on your case. They may help coordinate medical treatment or get approval from doctor's offices or be involved with potential returns to light duty or full duty employment. And the change that's been made is to basically make it where the insurance company can choose to appoint a nurse case manager on your case. Used to, the appointment of a nurse case manager had to be mutual. You and the insurance company both had to agree. That's no longer the case under the law. The insurance company can appoint a nurse case manager unilaterally, which means they can do it without your consent or agreement. Now, there are some specific rules about what nurse case managers can do on your case. So since you are no longer necessarily involved in their appointment, it's very important to know what they can and can't do about your case. So that's another recent change in the law that's very important. The third recent change in the law that's important is a change in the panel of physicians, which is the list of workers' compensation doctors that your employer should have posted. And basically, when you get hurt, you have a right to choose a doctor off the panel of physicians to treat you and to change to a different doctor off the panel. The change in law that's important is the removal of the associated, or rather non-associated requirement on the panel of physicians. Formerly, the doctors who were listed on the panel, and the panel was required in most cases to list at least 6 doctors, could not be associated with each other. Potentially, if they were associated, it made the panel invalid, which meant that you could go treat with any doctor you wanted to. However, a recent change in the State Board of Workers' Compensation rules removed that non-associated language. So now employers can potentially include associated doctors, doctors who have a relationship with each other, or doctors potentially even at the same practice as each other, and still have them count as separate choices on the panel so that the panel can still be valid. This can cause you a significant problem because it may not give you as much choice about the doctors you treat with on the panel. Think about it. If all of the doctors listed on the panel of physicians are at the same practice, then really you don't have separate choices among your doctors. How likely is a doctor that is the same practice with another doctor to disagree with that doctor? It's not particularly likely. So it really doesn't give you much choice, and it really doesn't give you much right to a kind of free change on the panel anymore either. So that's another rule change to be concerned about. I hope you found this information that I provided in this video helpful. If you have, the best way to let me know is by giving this video a thumbs up or by liking it. If you have other questions about workers' compensation, there's 3 good ways to get some helpful information about it. One is by visiting our website, www.perkinslawtalk.com, where you can read articles that I've written about workers' compensation on our blog there. You can also visit our Perkins Stuttered Workers' Compensation YouTube channel and view the other videos from the Georgia Workers' Compensation video series there. The third way, if you have some specific questions, is to contact me to set up a free consultation. There's 2 easy ways to do that. One is by calling the phone number at the bottom of the screen, and the second is by completing the free consultation request form on our website I mentioned earlier. Once you submit that, we'll reach out to you at the phone number or email that you provide and schedule a consultation. Thanks for watching today, and I wish you the best of luck as you recover from your injury.